Before we start in class, I beg. Hello everyone. Hello, good afternoon. Can we all hear me?
Good evening, sir. We can hear
Yes,
you.
sir. Good evening.
Good evening. Yeah, good evening. Welcome to class. Thank you all for joining. We are happy to have you in class. Please, I would just like for us to reach out to others that are supposed to be in today's session but are not currently here. Members of this class that are supposed to be here that are not here, please reach out to them so that we can have a full class and we can get to well, like I said, have a full class. But not to waste any time, right? We already have one of our mentors in class. Thank you so much, Miss Shukuras, for joining. We are happy to have you in the session today. So I'll just go straight ahead to discuss our agenda for today, what we have planned for today. In today's class, we'll be starting off with presentations from the mentees, right? And then we'll take presentations from mentors. After that, after the introduction of the mentors, we'll take presentation from mentees. We'll take mentors' presentations and feedback, and then we'll do questions and answer. And that will be it, right? We'll do questions and answer, and that will be it. So just to go over to introduce our mentors in today's class. Our first mentor for today, our lovely Miss Amusa Shukurat Modupeola. Shukurat is a seasoned intellectual property consultant, analyst, and educator with public sector experience. She holds a master's degree in intellectual property from the prestigious African University Zimbabwe in collaboration with WIPO and the Japan government. Shukurat is an alumni of the World Intellectual Property Organization, a member of WIPO International Network for IP Education, as well as a trained facilitator at the Next Innovation Hub. She was a member of the planning committee for the WIPO National IPSC Competition 2023 and resource person at the National Intellectual Property Conference, NIPC. Shukurat is an accredited agent at the Intellectual Property Office in Nigeria and the pioneer of the Intangible Nuggets, an educational platform which is responsible for fostering, amongst other things, intellectual property, advocacy, awareness, and education. Thank you so much, Mark, for joining in for today's class. I'm sure this session is going to be interesting and we are going to have a great discourse. You're welcome, Ma. Our second mentor that we expect in class today is Mr. Rakesh. Mr. Rakesh is not yet here with us, but we hope that he will join us. Excellent understanding of patent law claims. Now he is ready engaged with various end-to-end IP services at different levels and provides intelligent IP solution innovation. For a better world. He loves drafting patent claims, keeping all the infringements. Hello, can we all hear me? Sorry, my network got disconnected. So sorry about that. If you have your speakers, if you have your speakers unmuted, please do kindly mute. Okay. All right. Once again, sorry for the break. I was logged out of the session. I was logged out. My network logged me out. So just to finish up, Mr. Rakesh's profile. So Mr. Rakesh, furthermore, he has a strong bent of mind towards IP automation and has sound knowledge of various IP tools and techniques that can be used for either improving quality of IP or increasing the overall productivity. He's an excellent mentor and possesses all the leadership qualities required for a successful IP. So those will be our mentors for today. The same mentors we had in the last class, that is Miss Shukurat and Mr. Rakesh. So just as a manner or as a matter of practice, or like I said earlier, we'll be taking presentations first from you guys, and then we'll have Miss Shukurat give us what she has prepared for us in class today, and then we'll take questions and answers, and we would call it a day. So please, our group presenter, please, can you kindly share your slides, start your presentation, and let's get straight to the business of the day.
Okay, so I'll do that immediately.
All right, thank you, Mona.
Okay, can anybody hear me?
Yes, we can hear you.
Okay, so I'm the group presenter for this presentation. I'm going to try my best to be as brief and as quick as possible because our presentation has 75 slides. That's a lot to fit into 10 minutes, but I'll do my best. So we understand from our previous class what patents are, but now we're looking into strategies for going about patents, understanding searches and legal requirements. So patents plays a central role in invention, protecting invention and driving innovations. They are economic and strategic assets that can define the success of a business. To fully appreciate the significance of patents, it is important to look at how strategies are built, how searches are conducted, and what legal requirements exist, and how enforcement and emerging technologies are reshaping the landscape. So, what is patent strategy? Basically, this is a person or company's plan to get the best out of their patents to suit their development goals in their businesses, in their personal endeavors. It's not just about legal protection, but about harnessing these patents as business assets, like money makers, to generate revenue for the company, aside going about protecting inventions. Key elements of patent strategy. Number one, we have purpose and goals. You have to understand why you are pursuing patents, why you are looking towards protecting your invention. Is it just to protect innovation, block competitors, generate licensing revenue? You have to understand the purpose and goals of your patents. Next up, we have patent filing decisions. Now, you make the patent filing decisions. Which inventions will you patent? Where do you want to have protection? When will you file? You have to know which ones are best for you. Number three, portfolio development. Now you've got to build a portfolio for your patents, a collection of related patents for easy viewing by possible investors. Number four, we have enforcement and defense. This is like a continuous monitoring of competitors to catch infringement fast. You've got to know your means of enforcement that suits your best interests and using your patents as a defense. Number five, we have commercialization and value creation. This is using your patents to make money, leveraging patents for licensing deals, joint ventures, or collaborations, attracting investors since patents can increase company valuation, generating revenue streams beyond direct product sales. Number six, we have risk management, conducting freedom to operate, that's FTO, analysis to avoid infringing on other people's patents. Also, filing strategically to block competitors from entering a market. Next up, we have innovative approaches to developing a strategic patent portfolio. It's about filing smart, being strategic with your filing to get the best market value for your protection at the lowest cost. Filing costs money, and you don't want to spend money on what won't exactly bring you value just because. There are strategies to these things, and I'm going to show you how. Number one, we have holistic innovation mapping. So this is you monitoring innovation trends and competitors to forecast future technology and going ahead to patent that. So you're like going into the future by prediction based on what you have currently trending to protect the next big thing. Number two, we have layered protection patent tickets. So now you're on one thing, protecting it in many ways. Protecting a core technology with multiple patents on not just the main invention, but also improvements and variations of that invention, the application and use cases of that invention, the manufacturing process. This creates a patent moat around the technology that's like a barrier that prevents other competitors from encroaching on your patent, making it hard for competitors to design around. This is mostly common in pharmaceuticals and electronics. Number three, we have patent plus data synergy. You're using two kinds of protections now. For example, with AI, biotech, and IoT, data itself has become valuable. Innovators are combining patent filings with trade secrets and proprietary data sets. The strategy here is to patent the algorithm or system, but keep the training data or optimization process as a trade secret. This creates like a dual layer of protection that is harder for your competitors to copy. Number four, we have dynamic modular portfolios. Instead of your static average portfolios, companies build modular patterns. These are broad foundational filings plus smaller targeted continuations or divisionals as the market evolves. This allows for agility, adapting the pattern portfolio to new products, standards, or regulations without starting from scratch. Number five, we have cross-industry and ecosystem patterns. Filing patterns that apply across multiple industries, e.g., AI in finance, healthcare, and logistics builds flexibility. That is, one patent family can serve different markets. It also supports ecosystem building, protecting APIs, in interoperability methods, or platforms to encourage partners while blocking rivals. So this way, you've used one patent to cover several industries, particularly in, obviously, artificial intelligence. Number six, AI assistant patent strategy. So now, because of the advancement of technology, we have tools to help us in going about our patent strategy. AI tools can now help us in predicting technology trends, identifying the white spaces, that's like the gaps that we forecast, suggesting claim language that maximize enforceability. Forward-looking companies use AI to continuously refine their patent strategy instead of reacting after the fact. Conclusion, to conclude all of that, an innovative patent portfolio strategy blends legal protection, market foresight, and business alignment. The smartest portfolios are dynamic, layered, and data driven, designed not only to protect inventions but also to create bargaining power, revenue streams, and long term competitive advantage. Next, we have methods for aligning patent strategies with small business goals. You shouldn't just have patents flying around. There must be some form of support and aid that they give to your business goals. If they don't, then they become unnecessary costs and just more work for you and your company. Here are some methods you can make sure that this doesn't happen, the unnecessary paperwork and stuff like that. Number one, we have start with business objectives, not just inventions. You've got to identify what you want for your business. You have to map out your goals and tie your patent filings directly to them. Number two, we have conduct patent portfolio or business fit analysis. This is a regular review of your patent portfolio against the company. The method here is regularly review your patent portfolio against company's product roadmap, revenue streams, and target markets. The key tools, patents, audits, technology, and production roadmaps. Freedom to operate checks. This ensures patents cover exactly what matters commercially, not just what was invented. Number three, prioritize patents by business value, not just novelty. So you rank and prioritize your patents by how much value they add to your business, not just by the novelty, how new it is. We've got we've got methods and tools to go about doing this. And number four, we have flexible global filing strategies. This is a strategy to file in places you know will be profitable to your business, not just filing anywhere. Places you know you would get direct revenue back, you would get value back for your patents there. Number five is leverage IP for partnership and investments. Use your intellectual property or industrial property, as the case is now, to leverage partnerships and attract investments. You use your patent as a bargaining tool in alliances, joint ventures, and fundraising. Number six, use patents defensively to reduce risk. You build a portfolio that provides for freedom to operate and countersuit against litigation. This supports risk management and reduces costly legal battles. Number seven, balance between patents, trade secrets, and open innovation. So still on how to use your patents to achieve your business goals, you have to strike a balance between your patents, trade secrets, and open innovation. You decide what are you going to patent, which invention to just keep as a trade secret. What do you publish to, form part of prior art to prevent competitors from possibly filing patents on those inventions? Yes. In conclusion, the best way to align patent strategies with business goals is to treat patents as a business asset, as a weapon to advance your business goals, not just to check legal boxes. This means patents should protect revenue, support growth, and enable partnership and strengthen market position, all while adapting to business changes. Now we are going to be talking about patent search. So, from understanding patents, we know that for your invention to be patentable, it should not fall under what has already been invented. A patent search comes to play here to help us understand what forms part of prior art. This is a process of identifying existing patents related to an invention or idea. Filing for a patent and acquiring a patent can be expensive. That is why you need to know what exactly is excluded from patenting at this point. Getting a patent for the invention ensures that no other person claims your invention as their property. Even if somebody else ends up doing so, by selling a copy of your patented invention or any other infringing method, they could be stopped with cease and desist letters and obviously legal recourse. Why a patent search is important. So, given that the patent offers its assignee the benefit to exclude others from infringing for 20 years, it only makes sense that patents should not be granted to every single idea. It's not everything that should be protected or should be restricted from public access. So patents are only granted to inventions that are unique and novel, non-obvious as well. Types of patent searches. There are different kinds of patent searches. The patentability, which is novelty search, the freedom to operate, FTO search, patent invalidity / validity search, and then state of the art search. Some of these searches are concluded before filing, others are concluded after a patent is granted. The patentability search, also known as the novelty search, is conducted before filing a patent application to ensure whether the innovation, the invention is new. The freedom to operate search. This is, it refers to the ability to sell or manufacture a product without infringing on others' patents. And FTO search identifies active patents that may hinder your ability to operate in the market. A patent invalidity / validity search. Yes, it identifies references that can question the enforceability of your patent claims. Why is this necessary? Patent examiners have limited time / resources, and litigation may challenge validity. This helps confirm enforceability before asserting, licensing, buying, or selling a patent. The state-of-the-art search. A state-of-the-art patent search provides a comprehensive review of all patents or non-patent literature in a field. Legal requirements for patentability in Nigeria. So we have Section 1 of the Nigerian Patent Act. Let me read it verbatim. An invention must be new, result from an inventive activity, and be capable of industrial application. So that is requirements for patentability according to Section 1 of the Nigerian Patent Act. So from this provision, we have 3 key requirements. Number 1, novelty. It must not form part of the state of the art. Number 2, inventive activity. Your patent, your invention must involve an inventive step. We got a rundown of all of this in our last class. Industrial application, it must be able to be used in any industry. Exclusions, that's like things that are exempted from patentability or patentable subject matter. Discoveries, theories, math methods, business methods, games, surgery, therapy, diagnostics, amongst other things. Even aesthetic creations, because they fall under a different kind of intellectual property. State of the art, everything made available to the public before the invention's priority date. So before you filed for a patent, everything that's available to the knowledge in the specific field forms part of the state of the art, forms part of prior art. The international patent landscape. The international patent landscape has become one of the most visible reflections of how nations and companies compete in the modern knowledge of the economy. Patents are not simply technical documents that record inventions, they are strategic assets, economic levers, and sometimes even political tools. Global trends. In recent years, the number of patents filed worldwide has continued to grow at a remarkable pace. Innovators are filing millions of patents applications every year, and the number of granted patents has risen sharply. This growth highlights not just the vitality of innovation, but also the importance placed on legal protection in an increasingly competitive environment. Moving on. Technology hotspots, the area of technology where patents are concentrated, tell an important story. Artificial intelligence, that's AI, biotechnology, clean energy, telecommunications, and semiconductors are among the fastest growing sectors. For example, in the biotech sector, CRISPR gene editing technology has sparked a global patent race between research institutions such as the Broad Institution in the United States and the University of California, Berkeley. The ownership of these patents determines who controls licensing rights for potentially life-changing medical treatment. Still on technology hotspots in telecommunications, standard essential patents are at the center of global competition. Companies like Ericsson, Sweden, Nokia in Finland, Qualcomm in the United States hold large patent portfolios covering 5G technologies. These patents are critical because any company producing 5G compatible devices must license them. You see how their patent has leveraged their business? The disputes over licensing terms between Qualcomm and Apple in the recent years illustrate how patents can shape the strategies of even the largest corporations. Regional differences and challenges. While the global patent system is interconnected, differences between national and regional regime continue to matter. Patentability standards vary. For instance, the United States has granted software-related patents more easily than Europe, which traditionally applies stricter criteria. This has influenced where companies such as Microsoft and Google choose to file patents on their digital innovations. Enforcement also varies widely from region and states. International mechanisms to address the complexity of filing in multiple countries. The Patents Cooperation Treaty, the PCT, has become a vital mechanism. Through the PCT, an innovator can file a single international application that can later be pursued in over 150 member countries. For example, a startup developing a new medical device in Canada might first file a PCT application to ensure an earlier to secure an early priority date while delaying the high cost of filing in multiple jurisdictions until investors and commercial partners are secured. Regional systems also play an important role. The EPO provide protection across multiple European states, making it easier for companies like several companies there to secure their inventions across the EU. In Africa, organizations like the ARIPO and the African Intellectual Property Organization, the OAPI, give innovators a way to protect inventions across multiple member countries with a single application. The future outlook. Looking ahead, several issues will continue to shape the international patent landscape. One is the role of AI in invention. Already, AI systems have produced inventions such as novel food packaging designs and drug candidates, raising questions about whether AI can or should be listed as an inventor. We've seen a lot of legal debates about AI owning copyright to images or works that they've created. This is another aspect of that. Courts in some jurisdictions have rejected AI inventorship, while debate continues in others. Another issue is access to green technologies. The urgency of climate change has led to calls for greater collaboration in this area. Finally, geopolitical tensions are beginning to affect patent strategies. What do we mean by this? The US and China, for instance, are competing intensely in areas such as semiconductors and artificial intelligence. This competition has implications not only for where companies file patents, but also for global supply chains and access to critical technologies. Now we're moving on to the international patent landscape. We made a comparison between Nigeria, US, UK, and France. In Nigeria, patents are governed by the PDA, the Patents and Designs Act, and are administered by the Nigerian Patents and Design Registry, the Nigerian Industrial Property Office, under the Federal Ministry of Industry, Trade and Investment. In the United States, federal patent law is in Title 35 of the USC. Patents are examined and granted by the US Patent and Trademark Office. Major modern reforms include the America Invents Act, the AIA 2011. In the United Kingdom, the national statute is the Patents Act 1977, which implements the EPC in UK law. The UK Intellectual Property Office, UK IPO, handles prosecution. The UK is not part of the EU Unitary Patents and UPC jurisdiction. In France, French patents are governed by the Code de la Propriété intellectual and administered by the INPI. France participates in the European Unitary Patents Framework, the EPO, Unitary Patents, and UPC. Core patentability requirements, what you must show. Well, for all four jurisdictions, they track the trade-related aspects of intellectual property rights as the TRIPS agreement minimums, the novelty, inventive step, non-obviousness, and industrial applicability/utility. All these things that we've discussed in the past class. The normal patent term is 20 years from filing across all of them. That's the TRIPS minimum. They are allowed to go higher, but they've all settled for the 20 years minimum requirement for protection. Yes, substance is similar. In Nigeria, the US, the UK, and France, they all require new and inventive and industrial applicability. The legal test and case law that implements those concepts, they differ. E.g., non-obviousness in the US under Section 103 versus the inventive step in the Europe, UK, and France. Examination, filing practices, and timing, the big practical differences. In the US, substantive examinations at the US Patent and Trademark Office, first to file systems since the AIA 2011. 1 year inventor grace period, that's like your priority period for disclosures by the inventor. Robust pre and post grant adversarial procedures, examinations, and post grant review, inter partes review at the PTAB. Wow. The UK and France, basically Europe, substantive examination is conducted by the national offices, by the EPO under the EPC. Europe has no general 1 year grace period like the US. There are limited exceptions, e.g., official exhibition disclosure within 6 months under the EPC rules. The unitary patent route lets an applicant obtain a single unitary right for many EU states via the EPO. Take note that the UK is not in the unitary patent/UPC bundle, as we've discussed earlier. In Nigeria, no substantive examination is commonly performed. Applications may be processed on a formal basis and patents can be granted at the risk of the applicant. Validity uncertainty is therefore a known practical issue in our country. Wow. Nigeria recognizes priority/PCT national phase filings and has limited novelty exceptions, e.g., exhibition rules. Subject matter and exclusions, that is like software, biotech, business methods, etc. In the US, broad statutory categories like process, machine manufacturer, etc., has a significant body of case law, limits patents covering abstract ideas, natural laws, or products of nature. We earlier discussed something of like nature under what cannot be patented. In the UK and France, the EPO approach, both follow the EPC excluded matter concept. In Nigeria, the Patent Act lists specific exclusions, e.g., plant and animal varieties, and importantly, computer programs are excluded as such. Enforcement and remedies. In the United States, strong civil remedies, specialized litigation venues, and trade remedies form part of enforcement and remedies. In the UK, patent litigation is handled principally in the High Court, the Patents Court, with remedies including injunctions, damages, and accounts of profit. London is a popular forum for global patent disputes. In France, national courts provide injunctive reliefs and damages. The European unitary routes and the UPC, for UPC members, also affect strategy. In Nigeria, patent actions are brought in the Federal High Court exclusive jurisdiction. Strategies for navigating the global patent landscape with ease. Number one, you have to use international filing systems like the PCT that we discussed earlier on and regional routes. Number two, rely on international search and examination. It gives you a broader database of what forms part of prior art. So in case you would like to file internationally as well. Number three, prioritize markets strategically. Focus filing on major commercial markets such as the US, EU, China, Japan, India, manufacturing hubs, enforcement-friendly jurisdictions. You don't want to file your patents in a place where you know if there's any likely infringement, it will be hard for you to enforce your patent rights. This avoids blanket filings that are costly but are often of low value. Number four, leverage patent databases like the WIPO Patent Scope, ESPA, CINET, the EPO, USPTO, Google Patents. They are very fast, they are free ways to check prior art and competitor activity. Number five, work with international IP treaties, the Paris Convention priority, 12 months. That is, you first file at home, then extend abroad within a year while keeping the same priority date. I would like to explain this a little bit. This means that if you file in a place that is party to the Paris Convention, it means that if you want to file in another place that is also party to this same convention, right, you maintain the same priority date. What does this mean? If you file in one member state in January, and then maybe you also want to file in another member state in February, and then for some reason they are now manufacturing your invention in that member state sometime in February, you still maintain January as a priority date. So that technology going on there is not really exactly any of your, or rather will not affect your filing for a patent. Yes. The TRIPS harmonization, basic standard, 20-year term, novelty, inventive step are similar worldwide, making strategies more predictable. Number six, tailor subject matter strategy. Software business methods. US may allow if technical. EU, UK, France are more stricter. Nigeria excludes software as such. Biotech and pharma. US and EU require detailed enablement and written description. Patent enforcement and litigation. That's the next thing we're going to be discussing now. So the court is conferred with exclusive jurisdiction to hear and determine disputes arising under the PDA. The court, now we're in Nigeria, apparently. The court is established by the Constitution with powers to hear and determine disputes on several matters, including disputes arising from any federal enactment relating to patents. So we're discussing how we can enforce our patent rights. Border control agencies also play a role in enforcing patent rights. The Nigerian Customs Service is empowered to search for, seize, detain, and destroy counterfeit goods brought into Nigeria. A patent owner may take advantage of this provision by raising a petition to the Comptroller General of the NCS. The process of patent enforcement and litigation. The patentee has the legal right to bring a patent infringement suit. Yes. A registered licensee may also institute an action for patent infringement If the licensee notifies the patentee of the infringement, the patentee unreasonably refuses or neglects to institute action, and the licensee files a copy of his or her notice to the patentee with the Registrar of Patents. However, the patentee has the right to intervene in proceedings brought by the licensee. Patent infringement proceedings are governed by the civil procedure rules because, well, this is not criminal litigation. The plaintiff commences a patent infringement proceeding by filing at the registry of the court via a writ of summons, together with a statement of claim. Basically, everything that is supposed, all the accompanying documents of a writ of summons. Many, I believe, law students would understand what I'm talking about here. The defendant is required to respond within 30 days of the receipt of the plaintiff's papers by filing a statement of defense together with a list of his witnesses and their written statements and the evidence it intends to rely on in the trial. The defendant may also file a counterclaim upon receipt of the defendant's filing. Upon receipt of the defendant's filing, the plaintiff may file a reply within 14 days. The action would be set down for hearing after completion of these filings. A patent cannot be amended during the course of the infringement proceeding. This is basically just talking about how the whole litigation process would go. However, where the defendant's defense is that the patent is invalid, the defendant must prove that the subject of the patent is not patentable. The patent fails to conform to the requirements for clarity and completeness. This is like the defendant's defense. Yes, that there was an existing prior application or grant of a patent in respect of that same invention. All process and procedure, invalidity of a patent as a defense in litigation. Okay. A defendant to a claim for patent infringement may challenge the validity of a patent as a defense to the suit. So he's saying that this thing is not, possibly the due process for filing the patent will not followed, it doesn't form part of, or that it's not exactly novel, anything that would discount it from being patentable. Yes. Okay. Other types of patent proceedings. Number one, declaration of invalidity. In addition to the action for infringement of patents, the court has exclusive jurisdiction to adjudicate an application challenging the validity of a patent. The court is also properly constituted when it is composed of a single judge. So you don't need multiple judges to adjudicate your case, or rather to judge your case. A single judge would suffice. The court may also sit with and be advised by experts where the court considers it necessary. That's like accepting expert testimony and expert evidence. Okay. Other types of patent proceedings. Proceedings for compulsory license, court sanctioned. The court also has power to hear applications for and to grant compulsory licenses in respect of patents. The application for compulsory license may be brought on several grounds. These grounds are that the patented invention, being capable of being worked in Nigeria, has not been so worked. The existing degree of working the patented invention in Nigeria does not meet, on the reasonable terms, the demand for the product. The working of the patented invention in Nigeria is being hindered by the importation of the patented article. Also, by reason of the refusal of the patentee to grant licenses on reasonable terms, the establishment or development of industrial or commercial activities in Nigeria is unfairly and substantially prejudiced. An application for a compulsory license on any of these grounds can be brought by any person at any time after the expiration of a period of 4 years after the filing of a patent application, or 3 years after the grant of the patent, whichever is later. In conclusion, patent enforcement and litigation are vital measures to ensuring that inventors truly benefit from their invention. Effective enforcement protects against infringement, encourages research, and clarifies the scope of patent rights. Now we're going to be talking about emerging technologies and patents. The rise of emerging technologies poses new questions for patent law. In fields like AI, blockchain, and biotechnology, the lines between human and machine contributions to invention is gradually becoming blurred. Should an AI created invention be patentable? If so, who then is the inventor? The programmer, the AI system, or the company that owns the AI? These are questions we ask every day due to digitalization and advancement in artificial intelligence. Blockchain also introduces challenges in securing patents for decentralized technologies where ownership and control are not always clear. These questions highlight the evolving nature of patent law and the need for flexible frameworks that can adapt to technological change. Now, this is the end of my presentation. These are the names of the group members who worked so hard to bring in about this wonderful presentation. I am very sorry if this presentation seemed a bit rushed. I'm trying my best to keep within time frame and not keep us way too long. It seems as though I have done just that. But anyways, thank you guys for listening. Thank you guys. And this is the end of my presentation. I'll stop sharing my screen now.
All right. Thank you very much. Thank you very much for Muna for your presentation or presenting on behalf of your group. You people had quite a very lengthy slides. I think about 70 something pages. Well, I think I'll leave it to the mentors to address that. I'm not sure. Okay, I think Mr. Rakesh is still here. I don't know, sir. Do you still have anything you want to say before you go? I saw your message. So sorry that we did not have you up first. Um, we did not have you up first to present. It was because you were not in class at the start. So we just want to find out if you have anything you want to share before you go, sir.
No problem. Actually, this session was for me also. I treated it as a learning lesson. So I enjoyed each and every slide Muna has presented. I was listening it very carefully. I was thinking people should ask questions, but nobody asked. Actually, the content was so elaborative. It was having 75 slides, but she has covered it in that time. But if still anybody has any questions, either related to patentability requirement, freedom to operate, or all other requirements she has highlighted, just I would want you to put one word, that is how and why. How you should do it and why you should do it. If you will put these two type of questions in front of all the requirements Muna has highlighted in front of you in all the 75 slides, it will be easier for you to either channelize your inventions as well as to help somebody as a patent consultant. You can help somebody else also to channelize and to make the best use of their inventions also. So these are the two suggestions I would simply say. Otherwise, content was superb. It includes everything, including from patentability, freedom to operate, invalidity, validity, competitor blocking, competitor intelligence. Everything was there in the content. But whenever you are facing any situation, you just need to ask two questions to yourself or to your clients, that how and why from this content, and then your problem will be solved. This is what I want to say. Otherwise, I was thinking that she has covered everything and left nothing for me. So I would have to say thanks to Muna only for sharing such a detailed presentation. But I want people to ask questions so that they should get clarity on each and every step. Because whatever we are saying, it is not as simple as we are saying it in one plain English sentence. These are having multiple interpretation, multiple do's and don'ts. So I would recommend all the attendees to raise your voice, to ask the questions, to get clarity related to how, why, and what. Then only it will be easier actually. Rather than simply following a procedure, it will be always difficult actually. So I would recommend all the attendees to ask questions that how we should perform the freedom to operate, why we should perform freedom to operate, and what is the requirement of performing the freedom to operate search. For only one aspect, I am telling you these three questions. And if you are comfortable understanding from the logical perspective about the answers of these, you can use these three for your own inventions or for your client's inventions. So this is my recommendations, just to understand by questioning everything about how, why, and what. Then it will be much more easier for you to multiply the innovative ideas of others into the patenting, and by patenting it you will be able to get maximum benefit of it. So I am putting a pause here. If somebody has any questions for me or Muna, feel free to ask.
All right. So before we leave, if at all there's any questions we would like to ask Mr. before he leaves, if there's any questions we would like to ask Mr. Rakesh, please let's go ahead and do so. Right. So that after that, then we would have Ms. Shukrat come on board. But for now, do we have any questions for Mr. Rakesh? Hello, everyone. Do we have any questions for Mr. Rakesh? Okay. I want to assume we don't have any questions for now. So please okay, Mr. Rakesh, you can go ahead.
No, no, no. I believe, like, because I have not presented anything, so maybe because of that. But whatever content she has presented, I would want people to read or go through that content again and read it from questions perspective, that how this thing should be performed, why this should be performed, and always have questions in your mind. And once you get a clarity from all 360-degree view, then only either for your own innovation or if you are supporting your client, you will be able to provide them or give them a better recommendations. This is my one suggestion. Otherwise, a template learning like copy and paste would not work in this IP field. We need to understand the nitty-gritties, then only we should be able to recommend something to somebody, because no two cases, no two scenarios, no two circumstances are exactly same every time. So this
All
is
right.
my recommendation.
Thank you so much, Mr. Rakesh, for your recommendation. I do hope that our mentees are taking into consideration everything that you have said so far, even though it was short. We really did hope that you would give us your presentation for today's class, but we look forward to having you in our other sessions, and we'll do well to give you the floor first to present, so that in case if you had to have to leave at any time, you'll be able to do so, sir.
Yes, yes, I will always be there to support everyone.
All right. Thank
Just
you.
a just a quick suggestion. Like, Muna has addressed almost all the points, but I would want people to just think from the perspective of, like, what is the difference between patentability and state of the art search? What is the requirement of freedom to operate search? And where and when invalidity searches are conducted? And considering you from both perspectives, what will be your response to that? Either you are the owner of a patent or you are an infringer. So how you will respond to that? So have all those questions in your mind and prepare all possible strategies according to that. So this is my recommendation from today's lesson.
Okay, thank you very much, Mr. Rakesh. So we've heard from the group presenter for today's class. We've also had some suggestions and recommendations from Mr. Rakesh on the topic for today. Please, if we have Miss Amosa Shukurat on board, please, ma, we would also want to hear from you. Based off of what you prepared for us in today's class, we would like to hear your discussion for today. You're welcome, ma.
Can you hear me?
Your
Anytime
voice
that
is
you
breaking, ma.
that you can you hear me?
Yes, we can hear you now, ma. Okay, Miss Shukurat seems to be having a little network issue. I'm sure she will be joining us shortly. Let's kindly just do well to give her a little time for her to join back in.
One more thing I would like to highlight from the title of this discussion, it is the patentability requirement. So if you have any idea, there is no like compulsory requirement from any of the patent office for you to perform a patentability. This is just acting as an extra safety net for you to save your time, energy, and efforts. That to get an opinion from some experts that whether the idea you are running after is actually having any worth or not. So this requirement is always optional, but considering the filing fee of the patent office, the getting an opinion from a patent consultant seems much cheaper. So this is the reason that patentability requirement seems optional and people want to get an idea from the patent experts before filing at the patent office. So this is not a compulsory requirement from the patent office. If you are 200% sure about your idea that it is not being practiced anywhere, it is not being used anywhere, then even if you are proceeding without any patentability search also, it is okay. But chances of getting that patent granted might always depend on the your knowledge areas or your knowledge boundaries. So always have that concept in your mind.
Thank you again, Mr. Rakesh. Thank you so much for sharing also, that point. Ms. Shukurat, are you back with us?
Can you confirm that you can hear me?
Yes, ma'am, we can hear you now, ma.
Okay, so sorry, I had network issue. So thank you very much for today's presentation, and I think we all need to give a round of applause to Muna. She did a well-deserved job. I felt like I was in a master class. Though there were not so many practicability, but the write-up showed that the group actually did the work. They put in the work to come up with that write-up, and it is well appreciated. So I think I also don't have a presentation for today. So I'm just going to speak to Muna's presentation, and I want to add to what Mr. Rakesh has said. So just like Mr. Rakesh has said, you have to understand how, why, and I'm going to add some other aspect as well. The first thing, you have to understand what exactly it is your IP all about. Is it an invention? Is it a trademark? Is it something that has to do with copyright? You have to understand what. When you know what, that's when you'll be able to now identify which one goes for which. Say, for example, if your idea is maybe a novel of something, then you'll be able to know that when it comes to books or novel, or literary work, it boils down to copyright, right? Then if your idea has to do with something that is technical, there may be patent. So you have to understand what. Once you have been able to understand what, the next thing you need to understand is why. Why do you need this thing protected? Is it worth protection? Should you stick to the traditional method of trade secrets? Do you need to register it? Why exactly? Does it have a commercial value? Because there's no point you going ahead to protect what doesn't have a commercial value. Or in this case, imagine you have a patent, but that patent does not have commercial value. It's not something that people are looking for in the market. It will just be there after getting your patent grant. It will just be on the shelf. It will be a liability to you instead of being an asset. So you have to ask yourself that question: why exactly do I want to do this? The next question you have to ask yourself is how? How do I go about it? Is this something I need to get an agent to work on it for me? Is this something I can carry out myself? How exactly do I need to go about it? And the next question is when. Timing is very important when it comes to intellectual property. I know like, there is a proverb that used to say that the patient dogs eat the fattest bone, but it's not the same in intellectual property. If you snooze, you lose. So there's nothing like there's this particular phrase I'm trying to remember, but I can't remember it right now. But when it comes to IP, timing is very important. Um, and so, when exactly do you want to do it? How soon are you doing it? Are you planning to exhibit in a particular place such that you have to look at the country wherein you want to file? Do they have provisions for grace period? Do you have to file your application before exhibiting somewhere? Things like that, you have to put them into place to understand the timing. When exactly do you want to file? And the last thing you have to look at is where. Where do you want to file this application in? Is it countries that you have strong market in? Is it a country where you have so many of your competitors? Do you want to compete with them in that country? These are questions you need to ask yourself, just like Mr. Rakesh has said. So it's not just strategy for strategy's sake. A strategy so that it can guide you on how to go about all of these things. And when you look at the what, the why, the how, the when, and the where, you realize that everything that Munachi has presented kind of fall into each aspect of what we have done. If you look at the what we're talking about now is patent, is invention. And if you look at why do you want to do it? Is it to protect your legacy? Is it so that you can get what's it called, return on investment, and so on and so forth? If you look at what strategy do you want to put in place to protect it? If you look at when, what strategy do you want to put in place to be able to protect it at a time whereby it's not going to be invalidated because maybe somebody already has a prior act that is similar to your work? And if you look at when, where, that brings us to the registration route in which you want to take. So I'll progress to, I think there are some few corrections I would like to make from the presentation. I can't remember the exact page, but there's a particular aspect where she mentioned something about examining international practices like the EU, the UK, the US vis-a-vis what we have in Nigeria. And she mentioned NIPO at some point. She mentioned that the Nigeria intellectual property is governed by the Nigeria Intellectual Property Office. At the moment, we don't have anything as such as a Nigeria Intellectual Property Office. The discussion has been ongoing for a very long time, but it hasn't been concluded yet. So we don't have a NIPO office, or all we have basically is we have an IP registry, or let me say the FMITI, that's the Federal Ministry of Industry, Trade and Investment, wherein there are now departments in that organization that houses the trademark registry, the patent registry, as well as the design registry. So the design registry, the patent registry, and the trademark registry are under, or are departments under, the FMITI. Then when it comes to copyright, because copyright is not an industrial property right, it's a different kind of right entirely. So copyright is not within that organization. Copyright stands on its own. And this is more of the reason why we don't have a NIPO office, because we don't have all of these offices together in one place. And as such, if you try to go online, what you will see majorly is the IPO, which is the Industrial Property Office, which guides, or which talks about the patents, the industrial design, and trademark. Then when you look at the copyright aspects, you see the NCC, which is Nigerian Copyright Commission. So I wanted to put that straight. Also, she mentioned something about the UK not being a member of the EU. Yeah, I think of recent, UK is no longer a member of the EU. The EU is the European Union, and under the European Union, we have the EU IPO for trademark, and we have the EPO for patent. So when it comes to either EU IPO or EPO, they have something called a unitary system, whereby when you register your intellectual property rights in under the EU, it covers all member states who are part of the EU. But unfortunately, UK is no longer a member state of the EU, and as such, if you register anything in the EU, it's not going to cover UK except you designate UK itself on its own. She mentioned something about grace period. So grace period, like I mentioned earlier, when you are looking at when, this is where grace period come in. What time do you have? Do you have enough time to protect this thing, despite the fact that it has already been out there? The country you want to protect it in, does it have a provision for grace period? You have to look at all of these things. So not all countries have provision for grace period. Some countries have 6 months, while some countries have 1 year grace period. I think in Nigeria, we have, I think it's 6 month grace period, if I'm not missing it. Then she mentioned strategies for navigating the global patent landscape. And she mentioned something like international protection. So I like to say that there's no such thing like a global patent. You can't say you have a global patent protection. Rather, the best thing to say is that there is there's international routes. So there are different routes to take when you are trying to file your patent application. It could be trademark, industrial design, and so on and so forth. So it's basically called routes, not global patent or global IP registration. And when it comes to this route, we have 3 basic routes. She tried to explain it during one of the notes under strategies, but it wasn't well explained. So when you talk about the route, we have 3 routes. We have the international route, we have the regional route, and we have the national route. I know she mentioned international and regional, but there was nothing on national. And so when it comes to international routes is when you are trying to file outside the confines of your country, like you want to file abroad. So what do you do in this sense, whereby you want to file maybe in 3 countries outside the confines of your country, and you don't want to go through each country to file? That's where the international route comes in. And this is where we have PCT, the Patent Cooperation Treaty. The Patent Cooperation Treaty is the filing route under international routes. And once you do this, what it means is that you are able to designate or select the countries you would like to file your application in within the period of, is it 36 months thereabouts, before you enter the national phase. And before then, you are able to decide if you want to proceed or not, given the result of your preliminary set report or your examination report as well. She also mentioned, okay, but then we also talk about the regional route. The regional route, like you said, is regional, right? So I also mentioned that the international route is should I say governed? I don't want to use the word governed, but it's administrative, is under WIPO, is an administrative aspect of what WIPO does. So WIPO basically look at the administrative aspect. They are not the one granting. All they do is receive your application, look at your administrative process. Do you put your name? Have you paid the fees? And then they send to the what do we call it now? Receiving offices. Then the receiving offices go ahead from there. They carry out the examination, the patentability report, and so on and so forth. And they send to the national offices at the point when you get to that stage. So WIPO has nothing to do with granting. All they do is just help you facilitate the process. And when it gets to the national phase, each designated country decides to grant or not, depending on their laws. So when it comes to the regional phase, you are looking at it regionally. And when it comes to regional, we have ARIPO, we have OAPI, we have the EU IPO, but in this case, we talk about EPO because we're talking about patents. That's the European Patent Office, EPO. So when it comes to OAPI, OAPI is the Africa Intellectual Property Organization, which is basically looking at the French-speaking countries. And we have ARIPO. ARIPO is the African Regional Intellectual Property Organization and is focused on the English-speaking countries. I think we have about 17 member states under OAPI, and we have about maybe 22 under ARIPO, if I'm not mistaken. But unfortunately, Nigeria is not a member of ARIPO. So what this means is that we can't file under the regional system. So if Nigeria wants to file in any country who is a member state of ARIPO, we have to get somebody like an agent or a patent attorney in each of those countries to file on our behalf. Then when it comes to international routes, Nigeria is a member of the PCT system. However, Nigeria is not a receiving office. So the same thing applies. You cannot file through the international routes directly from Nigeria. However, you can file using the PCT platform, the ePCT platform hosted by WIPO. Now, when it comes to national routes, like the name says, national, you want to file in your own region where you are. You are an inventor in Nigeria and you want to file in Nigeria. You go through the national system. You are an inventor in Indian and you want to file in Indian. You go through the national system in Indian, and so on and so forth. And the same thing applies if you are an inventor in Indian and maybe you want to file your patent application in Nigeria, then you have to get an IP agent or a patent attorney in Nigeria to file on your behalf. That's how the national system works. It's just one country. Then when you look at regional, it has to be those countries who are member states of that regional body. Could be ARIPO, could be OAPI, could be EPO, and so on and so forth. So each IP element have their own routes. So when it comes to international route for patent, we'll talk about the PCT. When it comes to international route for trademark, we'll talk about the Madrid. When it comes to international route for industrial design, we'll talk about egg. When it comes to international route for graphical education, you talk about the Lisbon Agreement. So each IP element has their own treaties and conventions. So the next thing I'll talk about is she mentioned something about still under strategies that you should work with international IP treaties. So I'd wanted to ask her how do you work with international IP treaties? Because these treaties, they are not bodies, they are not entities, they are just laws that have been put in place to guide us on how to go about all of these things. So it's not possible for you to work with them, but all you can do is you can adapt them into what you are doing. And when you talk about those treaties, especially when it comes to patents, you talk about the Paris Convention, you talk about the TRIPS agreement, you talk about the patents, is it patent treaty? You talk about the Strasbourg agreements and so on and so forth. There's so much. However, when it comes to priority, so each of these, or let me say majority of this treaty kind of adapts from, or were kind of adapted from the Paris Convention, because the Paris Convention is a convention that talks about the industrial property right, which is patent, trademark, industrial design, and so on and so forth. So most of these treaties have come to better what were not included in the Paris Convention, or they've come to make an addition to what was to things that are limited in the Paris Convention. So when it talked about priority or right of priority, even grace period, they are all bettered from the Paris Convention. However, when you look at the aspect of medicals and pharmaceuticals, compulsory licensing, voluntary licensing, you talk about the TRIPS agreement. So you have more of compulsory licensing, voluntary licensing, and so on and so forth, especially when it comes to pharmaceuticals under the TRIPS agreement. So each of these treaties has what it focuses on. So I think that would be my wrap up. Then for the aspects where we have enforcement, well, I understand that it's more or less like a copy and paste, because the way it is in the book is different from how it works in practice. So you might not always rely on what you read in the book. Whenever you are practicing as well, you get to pick one or two things at the end of the day. Yeah, so thank you. That will be my review and addition. Thank you so much, Dennis.
All right, thank you so much, Ms. Shukurat, for wonderful highlights into everything that was discussed in the presentation. You talked about very, very key points that I hope we were paying attention to. So please, for those who are in class, please, if we have questions, we'll be taking questions now. So if you have a question you would like to ask Ms. Shukurat, please, so that we can we can use this as also an occasion to get more in terms of, trying to find out more as regards to this topic. Let us try to do that. So please, if you have questions for Ms. Shukurat, let's go ahead and ask our questions. Do we have questions? Guys, can we hear me? Please, let's ask questions.
Okay, my question is kind of bordering on what Mr. Rakai said before leaving. He mentioned that there are some certain things that we should also still consider. And I want to ask, actually, what is the difference between a patentability search and a state-of-the-art search? Because a patentability search involves novelty, and it's kind of similar to what the state-of-the-art search is doing. So are there any form of differences, or whether one can go with one and discard the other? That's my question.
All right, thank you so much, Muna, for your question. So most times each of these type of searches, it depends on what exactly it is you are doing. So like the name says, patentability search. Patentability search borders basically on you checking for newness. Like, what are the patentability criteria? Is it new? Is it inventive? That's what patentability search borders on. So more you trying to get a prior act to see if it's not going to invalidate the application you are currently working on, which you intend to submit. That's patentability, just to see, does it pass the patentability test? Yes or no. Then when it comes to state of the art search, that is more likely on the technology, is more likely on the technology. And when you are using state-of-the-art search, then you kind of go into, I think I saw it during your presentation, you go into the international search using the, what's it called now? The classification method for patents, to try and see, okay, this industry or this company, which technology do they focus on? So you're trying to focus on what these people are doing. Are they into medicine? Are they into tech? Are they into this? Are they into that? So it's more or less like, or is more of the technology, the state of the art. Which technology are these people involved in? Compared to patentability, that is just looking at newness and novelty. Then when you're looking at invalidity search, as the name implies, invalidity. In this case, you are trying to invalidate somebody's search. So you are trying to look for an application that maybe can invalidate the other person's application, such that that application will be withdrawn. So most times when you are doing this kind of invalidity search, is majorly when you probably have a competitor who has been granted a patent application and you feel like this person shouldn't have been granted this application. You can now decide to raise your opposition and say, okay, I think this patent should be granted based on the fact that it's not valid. It could be, when it comes to invalidity, it could be invalid depending on based on novelty. It could be based on prior act. It could be based on inventiveness. That's invalidity. When you talk about freedom to operate, You want to see where exactly can I operate such that I'm not infringing on an already existing invention. So these are the types of searches. So that's why Mr. Rakesh said you have to understand when exactly do you need them? How can you use them so as to better help your client or even you as the consultant? I hope that answers your question, Muna.
Yes, ma'am. Thank you.
You're welcome.
All right, thank you very much, Ms. Shukras, for helping us out with that question. Do we still have any other person with a question in class today? Please, let's ask questions. All right, Aisha, please go ahead and ask.
Let's put on our videos. Let me see my student's face. Okay, you want to see maybe you should see my face too. I actually want to see Muna's face. I want to see the face of today's lecturer. Yeah. Aisha, you can go ahead with your question, please.
All right. Good afternoon, everyone. My question is that, is there like a public record where all registered patents are stored so that it's very possible as a person that you think that your innovation is new without checking that record, and then when you want to patent it, you not realize that something else has already been patented, has already been, registered as a patent before. So is there a public record where all patented innovations are stored?
Okay, thank you so much for your question. But before I respond to your question, I'm just saying Muna. So Muna, can you just give a brief introduction about yourself? I want to be sure if it's the Muna I know.
Okay, my name is Munachimi Wando Chukwemeka. I am a law student in Bingham University, currently in my final year.
Which university is that?
Bingham.
Which university? Can you come again? Which university?
Bingham
Okay,
University.
okay. That's in Abuja, right?
Yes, ma'am. Well,
In
yeah, kind of.
Abuja.
Yes,
Okay.
along that line. Is there any other thing you'd like to know,
Okay.
ma'am?
All right. Thank you. I
Okay.
think that's fine. I know one Munachi. I know she's a graduate. So I wanted to be sure if it's the same person. So
Okay.
Aisha, back to your question. I know Munachi, it was somewhere in Munachi's presentation about patent search and patent databases, such as the WIPO patent scope, the ExpertNet, the Google patent, and so on and so forth. So there are some databases that are paid, while there are some that are free. So for example, most of the databases from USPTO, ExpertNet, WIPO, that's a patent scope, and Google Patent, they are majorly free. Even if you look at JPO, that's the Japan Patent Office, they are majorly free. But unfortunately, the Nigerian database is not available, and that is why we can't carry out public search on the Nigerian database. And so this is where patent search comes in. So the first thing you want to do when you're trying to look at if your application or your invention is new is to carry out a patent search. Now, carrying out a patent search is also a strategy. Mr. Rakesh said it earlier that you might not do a search if you feel like you've done all your homework and you don't need a patent search, but most times you might not see what the examiner will see. So when you do a patent search, you have to use these databases to check whenever you're trying to do a patent search. And I think Mr. Rakesh showed us a preview last week using, was it Google Patent, if I'm right? I think it was Google Patent he showed us last week. He was trying to carry out a search on Google Patent. So all these databases are available for patents that have been either be published or accepted. You see them on databases. So you can just go through them, either Google Patent, Patent Scope, ExpertNet, USPTO Patent Database. There's also one called the Glossary. Don't let me murder the English. She's glossary, like it has almost all the there's something we call IP5. Those are the top 5 countries that have a strong IP system. That's USPTO. I think China is part of it. SIPO, UPO, EPO, USPTO, KIPO, JPO. You can just look at it. So you see they have a patent database that is accessible that you can look at. It's just that when you won't be able to access the one of your country if the one for your country is not accessible. So in most cases, when we have searches to run, we just use maybe Patent Scope or Google Patent. And even after doing that, you still have to carry out a search from the patent registry, so they can give you their own result as well. That's if you are doing in Nigeria. I hope that answers your question, Aisha.
Yes, thank you, ma'am.
All right, you're welcome.
Thank you very much, Ma. So please, do we still have more questions? Any questions before we go? We are in our question and answer segments, so please let's try as much as possible to ask as much questions as we can, right? I'm sure Miss Shukurat, sorry, ma'am. I'm sure Miss Shukurat is ready and also prepared to help us answer our questions. Any more questions, please? We are still taking questions. All right,
Okay, I think
Ugochi, please.
Ugochi has a question.
Yes, you can go ahead and ask your question.
Okay, good evening, ma. Good evening, everyone.
Hi,
Um,
Ugochi.
okay, based on our lessons today, I think I learned that mostly about patent search, yes. But I want to verify based on the fact that we are in Nigeria and we understand that our technology, we are not really like I will, how will I say it, that we do not have most of these things properly documented. Is there a possibility that even after a patent search, that later after the registration you could still see another patent later? Like I still believe that there could be that possibility. What do you now do in that particular case?
Okay, so I'm still going to refer you back to Muna's presentation. If you go back to that presentation, you will see she mentioned something about formal examination and substantive examination. So in countries whereby they have very good patent standard, they do a substantive examination. But unfortunately, countries like Nigeria, South Africa, I think Egypt does substantive. And some other African countries do not do substantive patent examination. So what we do is basically formality. And what this means is that by not doing substantive examination, we won't be able to examine that application as to that criteria of novelty, industrial applicability, and inventiveness. We are just going to examine the application based on formality. Okay, does this patent application have a name? Is the name under the patentable subject matter? Do we have the name of the inventor? Do we have the title of the invention? Do we have abstract? Do we have body of the patent of the application? Do we have background? Does the application has claims? Those are administrative. So those are the formality examination. But when it comes to you checking it vis-a-vis other patent application or prior act, we actually do not do that. And as such, it is very possible for you to get your application patented and somebody else comes to oppose it and say, oh, this patent is infringing on what I have. It is at that point, both of you will now go to court. It is then they will now say, fine, let's try and see both applications and see which one is new, which one is inventive, which one is industrially applicable, and so on and so forth. So what we do in Nigeria, it's more or less like formality sake. It's not really substantive. And as such, your question, yes, it's most likely going to happen. I hope I answer your question, Oguchi.
Yes, ma'am. Thank you.
All right, you're welcome.
All right, so in the absence of any other questions, if we don't have any more, we would be taking our pictures right now and we'll be calling it a day. So please, if you can, turn on your videos so that we can take our quick screenshots and then we'll call it a day. My video is turned on
Where, Dennis, where are the men in this class?
I think surprisingly
Are
we
they
have
all
more women.
ladies? Oh, wow.
No, I don't think they are all have more men in this particular class than more women, I mean, than we have men.
Okay, that's good. We are having more patent girlies in the industry.
All right, so I've taken our pictures.
Okay.
Thank you so much, everyone. Thank you so much, Mrs. Shukurat. Okay, I can see she just turned on our video. All right, also Aisha. All right, we are still done. Thank you very much, everyone, and welcome. Sorry, did I say welcome? Sorry, Ma, you wanted to say
Thank you
something?
so much, Dennis. Yeah, I was saying I want these particular pictures because we are just girls. So you had patent girls in the building.
I've ruined the picture for you people.
All right. Thank you so much, Dennis.
Yes, all right. So please do well to make sure to fill in your attendance and share what you have learned in class today. Also, do not forget to tag Ms. Shukurat and Mr. Rakesh, in your postings that you'll be making. Um, please do all have a lovely evening and take care. See you all in class next week. Bye-bye.